Hey, what's going on? It's Gary Geiman with Dominate Partners, and I wanted to talk to service business owners, home service business owners. That runs the gamut. A lot of my followers are in the pressure washing, window cleaning world, but there's also carpet cleaning, junk removal, plumbing, electric, dryer vent cleaning, roofing, decorative concrete, garage floor epoxy contractors. The list goes on and on and on and on. If you service homeowners, then I want to talk to you if you own a business. So I follow a lot of stuff on YouTube and see a lot of things on YouTube, and as is typical, things that you see, you have to kind of understand who's saying it before you believe that it's true or not. And I know in your industry, in the home service professionals world, regardless of what vertical you're in, the biggest issue that you face related to employees, it typically is the fear of hiring them because you're afraid you're going to train your competition. That's typically the biggest fears I see or hear. Obviously, there's other issues related to employees that we can get into, but when it comes to why you don't want to hire employees, it comes down to that fear of training your competition, which is, it's definitely a legitimate fear for sure. But I believe that it's unfounded. Like, it's unnecessary to have that fear. And I'm not making this video to talk about that. I'm making this video to talk about non-competes and non-competition agreements in home service professional businesses. Here's the deal. And the reason why I'm making this is because the person who I watched was basically putting a non-compete agreement in place, and he's not an attorney, and it sounded like he wrote it himself, and he definitely was giving it advice that wasn't from an attorney. So I'll give you my background real quick. Number one, though, I'm not an attorney. Not an attorney, but I have spent many hours in a courtroom. Not criminally. I used to work for a company that we were very litigious, very litigious. We sued companies, and I spent a lot of time in mediation. I spent a lot of time in courtrooms. I spent a lot of time with attorneys, and in fact, at that company, I had signed a non-compete, non-disclosure agreement because their business model and the way that they did business in their mind was unique. So, not being an attorney, I understand the ways that the court system works. And this person who I was watching on YouTube talk about his non-compete that he's going to put in place for employees basically said that non-compete was going to protect him from that employee, that any employee that he hired, from going and starting a company in his market. And that's just not true. Regardless if you or I agree that a non-compete is something that can be held up in court, or that is something that can be enforced, let's say, you have to understand how you have to enforce the non-compete. Number one, you're going to have to hire an attorney because you are a non-person. You're a business. You're an entity. And in almost every state, unless it's a small claim, and when you're going to enforce a contract of a matter related to employment, it won't be small claims. You're going to have to hire an attorney. You're going to. You're gonna go hire an attorney that is versed in employment law. The first thing about that is that's not cheap. Well, I'll collect whatever I have to pay for my attorney from the person I'm suing if I win, or when I win. Maybe, maybe not. Like, you're assuming that a judge is going to make a determination on your contract. You see, the way court works is this. The court system was set up for two parties to come together and basically figure out a resolution to the matter. And if that resolution could not be figured out, then they both would plead their case before a judge who would then give his ruling. Most judges do not want to give rulings. So they will put you through this pretrial process of discovery. That costs money, of interrogatories, which then leads to interviews back and forth between their witnesses and your witnesses. They're called depositions. That costs money. Then there's going to probably be more discovery because of the depositions, that information that was gathered during the depositions. There's going to be more discovery. That discovery costs money. It's not cheap. Like, you're paying an attorney by the hour, and these attorneys make $150 to $250 an hour, depending upon where you're at and how good they are. Like, you have to realize you're going to spend a lot of money to enforce this non-compete to keep your employee from competing against you. I've seen a company spend $15,000 to defend a non-compete, and then that non-compete was resolved in a mediation setting where they agreed to terms that had nothing to do with the non-compete. So let's talk a little bit about what would be enforceable in a non-compete. Number one, the non-compete, if you set one up, has to be reasonable. Has to be reasonable. Look it up. Look it up. It's the law. The non-compete has to be reasonable. It has to be reasonable to both the employer and the employee. So what is reasonable? Well, telling someone that they can't work within a 100-mile radius or even a 50-mile radius, sometimes even a 30-mile radius of their home to make money is not going to be reasonable to any court. I promise you. A judge is going to say that that person has to have the ability to make money. And if that has been something that they've made money doing, then that person's attorney, who, by the way, if you sue someone who's poor, it's really easy for them to go find an attorney. People will represent the poor. They're not going to represent Mr. Businessman for free. But attorneys will represent people who don't have money for little to no money. So it has to be reasonable. So the radius to which that you can compete is going to be very minimal, typically 15 to 20 miles. Secondly, no court is going to keep someone from making money. They just aren't. And so if that's the way they make money, like, a court's not going to just enforce your full non-compete. Like, it just isn't going to happen. Thirdly, like, what is it that you do that's so secret? Like, can it not be found? Can it not be trained? Like, do you really have something that should be kept secret? Like, if you do, like, if you do something in your process that nobody else does, and you know that for sure, and you're not getting on Facebook and you're not getting on YouTube and spouting it off to everybody, then okay. But do you do something that isn't or is top secret? Do you? Like, that's that's what you need to have a non-compete. I can tell you what is enforceable. Having your employee not be able to contact your customer list for a period of time. Now, it won't be forever, because again, it has to be reasonable, but let's say 24 months, 36 months. That time period is reasonable for an employee not to contact your customer list. What else is reasonable to expect from an employee? Well, it's reasonable to expect that they won't steal financial information, or they won't steal information about your company and then try to use it to beat you in your market. Like, that's something that's reasonable, and that's something that you actually could put together in a non-competition or non-disclosure agreement. I can tell you that non-competes typically are only enforced by courts when someone sells their business. They're not enforced when someone works at a home service business and they don't want them to compete. You have to come up with other, more productive ways to beat the competition than just by making them sign a non-compete if you hire someone and you're afraid that they're going to go into the world and start their own business doing exactly what you do. It happens. It's going to happen. It's always going to happen. Nothing makes you special where you should be the only business owner in your field and your market. It's not the way it is. I'm sorry. But you can be aggressive in making sure that nobody else wants to do business with anybody else in your market. And that is by being all-consuming in your marketing efforts, in your operations efforts, and making sure that your name, your company name, is the only one that shows up when people think about your services, when people want to hire your services. Like, that's how you protect yourself, not figuring out a way to put together a 4 to 5 page document that you then have to pay a lot of money to enforce, go into mediation to come up with a resolution that isn't the agreement. Doesn't make sense. So if you're going to have a non-compete, and I'm not telling you that you can't, I'm just saying that they're kind of a waste of time. If you're going to have a non-compete, put the things that are reasonable. They can't contact your customers for a long period of time, 24, 36 months. I don't know if you're going to get 36, but let's say 24. They can't utilize insider information to go and start up a company. Like if you have a supply source and that supply source sells you material, equipment, whatever, at a really reduced price, or because of a relationship you have, they can't try to circumvent that relationship and get the same thing. All other non-competition agreements, they're going to be difficult to enforce, and that's the key. You have to enforce them. So think about that the next time you think about, I'm going to get a non-compete, keep my competition from doing anything. Look, a non-compete is only the barking dog. Like, if you want to add bite to the dog, you have to hire an attorney and enforce the non-compete if somebody quits. Is it a good barking dog? Maybe. I mean, it's going to speak to the level of employee that you have who is afraid of a non-compete. I can tell you that I had a non-compete, non-disclosure, and when I left the company, I got a very long compensation plan that ranged 8 months so that I wouldn't compete, because that's the other thing. There has to be value assigned to the contract. The value to the employer is they're not going to compete against them. The value to the employee has to be equal to that. And so, I received a 6-figure settlement to not compete against my employer. Think about that. Is that what you want? And don't say, it's different. It's different. No, it's not different. You got to deal with the courts. You have to deal with the courts. And I can tell you, dealing with the court system, dealing with attorneys suck. It sucks. It's not a fun thing. It's no fun for anyone. It costs everybody money. And until you've been through that many, many times, it's going to take you a while to figure that out. And I'm sure I'm going to hear comments, yeah, but I did this, and yeah, but I did that. Great for you. I can tell you, for most people, it's going to be futile. It's going to be futile. So don't spend your energy on that crap. Spend your energy on finding quality employees, training them, putting quality systems in place, having quality marketing, having quality sales, having quality operations, and having a business that you love, that you don't have to care about a daggone non-compete. If somebody quits, they quit. You replace them with somebody new, and you move on. That's how you run business. And that, my friend, is how you dominate your market. Let's dominate.